or the voluntary liquidation or the personal guarantor to corporate debtor, whatever the cases are there, it is very easy. And everybody will like you and they will get advisory services from you also. This is only my suggestion. Now, today's topic is on anatomy of IBC case losses, particularly 19 series. In this series, I will discuss about five, that is recent cases. The next Education India Private Limited versus Messrs. K12 Techno Service Private Limited, that is Supreme Court of India. Not only that one, Ajay Kumar Radhashyam Goenka versus Tourism Finance Corporation of India Limited, that is a second one. Third one is M. Suresh Reddy versus Canara Bank and others. Third one is Messrs. Vistara, ITCL India and others. And Mr. Dinkar, Venkat Subramanian and another. The last one is Pittampudi Salalita and the State Bank of India and others. These five, in brief, I will discuss. And these cases, how the Supreme Court is given verdict or judgment is some rationale is there. Then that rationale we will reiterate, we will rediscuss at the end of the case also. The first case is Next Education India Private Limited versus Messrs. K12 Techno Services Private Limited. This is a Honorable Supreme Court of India given the verdict. Supreme Court clarified position on limitation period bearing operational claims arising out of multiple invoices. Sir, here, while framing the IBC code, also everybody knows about the limitation period as per the Limitation Act, Indian Limitation Act. That is also applicable in IBC cases. In most of the cases, the judiciary authority also not admitted the case on account of time-barred debts. Further, if you go to the Limitation Act, at the end of the Limitation Act, schedule is also there. What are the various documents? What are the period of limitation? All are there. So, if you go through that one, then it gives us some idea about the Limitation Act. Not only that one, Limitation Act, two important sections, particularly from the banker. Being a banker, I am from State Bank of India, and two important sections are known to the bankers. One is section 18 of a Limitation Act. The second one is section 19 of the Limitation Act. Section 18 of the Limitation Act, part payment of the debt or acknowledgement of the debt, these two are very, very important from the banker's point of view. Why? Because whenever the bankers are taking documents for the loans given by the banks as per Indian Contract Act or a Transfer of a Property Act or various acts, they are taking the agreements. Each agreement is a validity period is there. The validity period can be extended by taking one important document that is called acknowledgement of debt or part payment of debt. Part payment of debt or acknowledgement of debt as per Limitation Act. So here, before going into the case, first let me discuss about the importance of the acknowledgement of debt. Bankers are busy, and sometimes whatever the documents are there, at the end of the third year, they may forgotten to obtain the acknowledgement of debt. They forgotten to take the acknowledgement of debt. Once they have not obtained the acknowledgement of debt, then it will be a problem. The documents are become stale document. Those documents are not executable in the court of law. So that's why some banks, their condition is after 2 years, 3 months, after 2 years, 3 months, what they will do is they will obtain the acknowledgement of debt, because 9 months before only they will take the acknowledgement. Why? Because last moment, if at all acknowledgement of debt is not given, then immediately the bank has to file the case in the court. Otherwise, the document becomes stale. But here also, the particularly the document, adequate stamp duty is to be required. Not only that one, the documents are, but most of the loans, either borrower is exclusive borrower is there. In some of the loans, borrower guarantor is there. Wherever guarantee agreement is there, the guarantor is also to be signed, and the bank will obtain one exclusive document that is called guarantee agreement. Guarantee agreement. So normally the documents, particularly for working capital, banks are taking hypothecation agreement. For term loans, particularly the plant and machinery and other things, articles of agreement or term loan agreement like that. And whenever they are giving any mortgage of property, mortgage deed also they will take. So whatever the documents they are taking, as per Limitation Act, each document validity period is there. But here, normally bank will 2 year 1 month or 2 year 1 month only, they will start the process of obtaining the document. But in recent cases also, some of the documents are time barred. But the Supreme Court also told, when the borrower is a corporate debtor is mentioned the liability in their balance sheet also, that is also deemed to be treated as acknowledgement of debt. That is also deemed to be treated as acknowledgement of debt. So not only that one, once the borrower is paid the amount in the loan account, the part payment, if the borrower is signed on the payment voucher, that is a loan payment installment voucher, then from that date also, the documents will revive for 3 years. So one is acknowledgement of debt, second one is a part payment of debt. These are to be mentioned in the Limitation Act, section 18 and 19. So every bank, they will ensure to obtain that one. Somehow recently what is happening, due to increase in the volume of the transactions, they are missing obtain the revival letter. But once these are obtained, particularly these are the mentioned by these are particularly these documents not obtained, then the loan, the agreements are become stale. That is not admissible in the court of law. But here, Indian Contract Acts also, without consideration, there is a contract. Without consideration, there is no contract. That is a general. But in certain cases, without consideration also, contract is there. In that also, time barred document, okay, I have given the document to the bank. I have given a document to the bank. That is a time barred. After 1 month, again I come to the bank, documents are time barred. Again, whatever the earlier date is there, I am acknowledging means that is also without consideration, there is a contract, that also to be treated as a document. That also fresh document in case of a stale document also validity in the court of law. That is, without consideration, there is a contract. Normally, without consideration, there is no contract. But sometimes, without consideration, also contract are there. That contract is belongs to that particular the time barred debts already there. Once the bank is time barred debt, the documents are not executable in the court of law. Later on, borrower is agreed. Then I have not given the acknowledgement. I am giving the fresh documents. Then they will mention about the previous documents. That documents are also valid in the court of law. Not only that one. Recently, Supreme Court of India also mentioned that whenever the company is mentioned in their balance sheet about the liability of the bank, that balance sheet is to be treated as acknowledgement of debt, that is loans taken by the company from the bank, that they mention in the balance sheet also to be treated as an acknowledgement of debt. So here, one more thing before going into the subject also, particularly the case, operational creditors. Whenever the company is providing any stock or any services, company is getting any stock or services from the creditors, normally company will accept the bill of exchange. Bill of exchange. Bill of exchange is called a trade document. The bill of exchange is called a trade of document. Suppose some company they are supplied some goods to me, raw material. Along with the raw material, they will supply the invoice. They will prepare the bill of exchange with the stamp duty. Third one is whatever the goods are sending by lorry, means LR receipt, lorry receipt, or if at all goods are sent by railway receipt, or if at all the goods are sent by airway bill of lading, AWB, or if at all goods are sent by the ship, the bill of lading is also there. And all these documents they will send to the corporate data, that is company, and the bill of exchange, the duplicate copy to be accepted by the corporate data while taking the goods from the company. From that date onwards, the validity period of the bill of exchange will start. Bill of exchange validity period is also 3 years. But here, being a insolvency professionals, whenever you are admitting the claims, whether it is a live crime, live or stale, that is to be ensured. Live means the document are in force. Like whenever the court is also, whenever I'm submitting the court for a case, CIRP admission, then the court is also doing whether it is enforceable or not. Enforceable means within the period of limitation as per Indian Limitation Act. So that's why the court is also verifying at the same time you should also verify the authenticity of the document, validity of the document as per the various statutory acts that are prevailing in the country. Now, the Supreme Court clarified the position on limitation period barring operational creditor arising multiple invoices. In this case, what was happened is the operational creditor, he has filed an application under section 9 by giving the notice under section 8, and whatever the various invoices are supplied, the goods are supplied to the company, all invoices they will enclosed with the particular form, that is application form for admission of that particular CIRP. So what was happened we will look into. and what is the final verdict of the Supreme Court of India? We will go into details. Supreme Court clarified the position on limitation period bearing operational criteria arising out of multiple. Here, the debt is particularly operational criteria. They are providing the raw material or services for each and every supply of raw material or service. They will obtain separate bill of exchange, separate invoice, separate whatever the transport document, and all these things they will provide. In March 2023, the Supreme Court of India Division Bench in Max's Next Education Private Limited versus Mrs. Catewell Techno Services Private Limited held that petition filed under Section 9 of the Insolvency and Bankruptcy Code based on several invoices, wherein some of the invoices are time barred. So, invoices means each invoice accompanied with the bill of exchange. That's why it is called a trade document. In the trade, the invoice and the bill of exchange are very, very important. Not only that one, goods acceptance report. Once the goods are received by the corporate debtor, after supplied by the operational creditor, he will give goods acknowledgement. That is raw material received like that. That acknowledgement, the bill of exchange, the invoice, and whenever the goods are supplied by the operational creditor to the corporate debtor, he will use any mode of transport, either lorry or railway wagon or air cargo or ship. Or sometimes he will use his transport document also. Whenever it is entered into the particularly factory, the factory gateman also he will enter into the register about the inward of the goods. All these things are proofs. All these things are proof. Why? Because if at all any puff transactions are there, preferential, undervalue, or fraudulent or extortionate transactions are there, this is also we can verify the cross checking, etc. So some of the they will create artificial invoices and all these things are there. For that also, we have to verify the cross checks, all these things. Particularly, this is a job of the transactional auditor. Normally, we call it as a forensic auditor. There is no term in the IBC forensic auditor, but it is a transactional auditor. So several invoices wherein some of the invoices are time barred. Okay. The adjudicating authority must consider invoice rise the least 3 years preceding the date of filing the Section 9 petition to determine the limitation. Actually, some of the invoices are 2014. Some of the invoices are 2020 or 21. And actually, adjudicating authority, while verifying that one, immediately they will look into the invoice. 2014, 3 years, 2017, whether acknowledgement of debt is there. No, then they will dismiss the case. But the Supreme Court told, once they filed the bunch of invoices, you have to see the latest invoices. All invoices are getting time barred, or some of them are in live. If some of them are in live, then the adjudicating authority has to admit the case. They should not dismiss or they should not disallow the case. So here in March 2023, Supreme Court Division Bench, Next Education Private Limited, India Private Limited, Mrs. K12 Techno Private Limited held that petition filed under Section 9 of the Insolvency based on several invoices, wherein some invoices are time barred and adjudicating authority must must consider invoice raised at least 3 years preceding date of the filing of section 9 petition determine the limitation. Facts of the case. Messrs Education India Private Limited is an operational creditor, provided digital class room services to Messrs K12 Techno Services Private Limited. That is corporate data. Between 12/3/2011 to 30/6/2017, nearly 6 years span, they have provided the services. That is Next Education Private Limited. They have provided services to K12 Techno Services Private Limited. So the operational creditor is Mr. Next Education, and this person is corporate debtor is K12 Techno Services. Particularly raised 187 invoices, because most of the invoices not honored, not paid by Messrs. Case 12 Techno Services Private Limited. There's a bunch they have enclosed. Bunch they have enclosed. In the light of non-payment of the corporate data, the operational data issued the demand notice under Section 8 of the I&B code, where the date of default mentioned as 12/3/2011. That is the first invoice date. First invoice date, he has given notice to the particular corporate data. They mentioned only the oldest, not the latest invoice. So they mentioned only the oldest, the first invoice, that was 12/3/2011, the first invoice, and subsequently initiated proceedings under Section 9 of the I&B code, where the date of default was mentioned as in 30/6/2007, and subsequently initiated proceeding. But later on also, the latest first default is the date of first default he mentioned as 12 March 2011, and date of default he mentioned as 30/6/2007, that latest mention, the date of last invoice. Because once the invoices are issued, and each invoice they will send some the correspondence with the corporate data by the operational data. But the first is 2011, latest is 2017. However, NCLT dismissed the company petition on the ground of a claim being time barred. Why? Because 2011 means, after 11 means the bill of exchange or invoice is a valid period is 3 years from 2011. 2011 means 2014 it is getting time barred. The same NCLAT, after lengthy consideration, decided that the Section 9 petition emanates from the demand notice. First demand notice he mentioned in the particular application also. First demand notice he mentioned. So Section 9 emanates from the demand notice issued under Section 8. The section read jointly. The sections read jointly. So once they mentioned about the default, first default, that is 2011 means next, naturally they will ask what is the latest, any acknowledgement date is there. If there is no acknowledgement date, then naturally they will not admit the case. The same was happened in this case also. Thereafter, the default shall matter be 12/3/2, which is time barred as per the limitation expired in 12/3/2014. 3 years. After 3 years, the bill of exchange or invoice is getting time barred. Once it is time barred, then that documents are not valid in the court of law. This said NCLAT order was challenged by the present appeal. Then particularly the operational creditor approached the Honorable Supreme Court of India. So they told that it is a time bound, but latest they have to take at least the latest whatever the demanded notice I have given, that also to be taken. Like that, the legal advisor he argued in the similar manner. Decision of the Supreme Court. The Supreme Court set aside the order of NCLT and the NCLAT. And while considering the starting point of the limitation is 12/3/2011, categorically stated that NCLT should have taken into consideration subsequent invoice raised up to the last 3 years, preceding the date of company petition. The company petition was held in the year 2011 or so, or the 2020 or so. By that time, the last, particularly the last invoice, not a time but you have to take at least that one, and case has to be admitted. Why the case is not admitted? Why you have taken the starting invoice only? He is 187 invoices. Whatever, at least, okay, whatever the old one is there, leave it off. The latest one is there. The latest one is live, and the debt is to be paid by the corporate data to the operational creditor, preceding the date of it rather than considering the starting point of the. So, Honorable Supreme Court of India, they have given judgment like this. The Supreme Court therefore settled the law regarding the determination of the limitation period, where the application under Section 9 of IB has been filed based on several invoices. So, whenever the operational creditor or the financial creditor also, suppose I take for example, banks are also giving different types of credit facilities to the borrowers. Either it may be the bank guarantee or a letter of credit or bills discount or working capital or term loan or temporary overdrawings or excess drawings. Different types of loan products are there. Some of the companies, almost all products they are availing with the banks. Whenever the default happened, only one account default, all will turn into non-performing. Even though 10 accounts are enjoyed by the borrower, out of 10, one is turned into non-performing. The one is remaining 9 also. Even though it is a standard, as per income recognition asset classification, that also to be turned into non-performing asset. So that's why whenever the several invoices by the operational creditor, or whenever the banks are filing several documents, banks are not submitting the invoices because it is not the supplier of raw material or services. Banks are giving loans. That's why he is called as a financial creditor. So, whenever the documents are there, out of these documents, some may be stale, some may be live. You have to consider the live, and the case is to be admitted, not to be rejected. Not to be rejected. This is a synopsis of that particular case. But why in this case also, what my remarks are, at the same time, whenever you are admitting the claims, whether the claim is in force or not, within the period of limitation or not, and time barred claims are not to be admitted. Once you are admitted, and in the resolution plan or liquidation, if you paid that amount later on, then it will become a problem. So whatever the claims are there, all claims are to be verified properly. At the same time, judicial authority has also to be verified properly. The genuine claim, once he believed that it is a genuine claim, and not paid by the corporate debtor to the financial creditor or operational creditor, then only he will admit the case. So here also, being a IRP or RP, whenever the claims are received, you have to follow the limitation period meticulously without any deviation like that. Any deviation like that. Sir, any discussion on this particular point, or shall I proceed for next case? Okay, I will proceed for the next case. Next one is Ajay Kumar Radheshyam Goenka versus Tourism Finance Corporation India Limited. Ajay Kumar Radheshyam Goenka versus Tourism Finance Corporation. This is also the latest case, and that also Supreme Court, and they have given this verdict. Signatures or directors of corporate debtor cannot be escaped the liability under Section 138 of NI Act 1881. On behalf of the company, the signature authority people, they are issuing so many the checks. Whenever they are issuing the checks, adequate funds are available. Otherwise, Section 138 to 141, 142 of NI Act, they are criminal libel. Criminal libel. Imprisonment is also there. In India, earlier, that 138 to 142 is not there. It stopped at 137 sections only in NI Act 1881. After that, they have introduced this particular the section 138 to 140. In that, whenever any person, whether it is an individual or partners of the partnership company or a signature authority or the managing director who is signing on the check or the director of the company who is authorized to sign on the check, whenever he is issuing the check, adequate funds are to be maintained. If adequate funds are not there, he should not issue the check. He should not issue the check. Once he issued the check, then he has to there. He is a punishable. He is a punishable. So that's why check bouncing cases, it is not only for the particular the company, but also to the individual. So once punishable means some of the directors they are going to escape from the punishment under the shelter of IBC 2016, which is not correct. Which is not correct. That's why the Honorable Supreme Court of India, they have decided, they have verified, they have read that the total history of that particular case, and accordingly, signature and the directors of the corporate debtor cannot escape liability. If at all any court imprisonment is there, whenever the court, even though we are talking, IBC will prevail over the other acts. But in this particularly punishments or imprisonment, that is not waived, even though it is under moratorium period or CIRP period like that. Further, one case is there. In March 2023, the Supreme Court of India In Ajay Kumar Radheshyam Goenka versus Tourism Finance Corporation India Limited, dealt with the effect of the pending proceedings under Insolvency and Bankruptcy 2016 on the proceedings initiated under Section 138 of the NI Act 1881. So, the Finance Corporation, particularly the Radheshyam Goenka, he has signed and issued a check to the Tourism Finance Corporation, and that check was bounced because the funds are not available, inadequate funds. Then he is punishable whenever the payee of the check filed an application with the court under Section 138 of NI Act. Then naturally, after verifying by the judiciary authority, the High Court, whatever the courts are there, they will give the imprisonment, or sometimes the penalty double the check value, etc. In this case, the facts of the case are Mr. Ajay Kumar Radheshyam Goenka, the appellant, was a promoter and managing director of Messrs. Rainbow Papers Limited, sought 30 crores from Tourism Finance Corporation of India, the respondent, to fulfill various corporate needs, to satisfy the obligations. Thus, the created appellant on behalf of accused company issued post-dated checks 24 lakhs 47,945, which was a dishonor. Consequently, the respondent demand come legal notice under Section 138 NI Act, and thereafter criminal complaint lodged under 190 of the Criminal Procedure Code 1973, read with Section 138, 141, 142 of the NI Act 1880. So, whatever that promoter or the managing director issued the check, that was bounced on account of inadequate funds. Once the funds are there, then only we have to issue the check. Once the funds are not there, you may issue the post-dated check, and you are expecting the funds. After 30 days means you have to give the post-dated, you should not mention the current date also. But this 138 to 142 is not applicable whenever the company is issuing any donation or CSR, and for that, if funds are not there, the check is bounced, then the other, particularly donee, that is a donee, he is not having the right to claim. Why? Because they are giving a donation. For that, it is an exemption. Other than that, it is not an exception. It is not an exemption. So in this case also, the post-dated check given, that on that day only the payee, that is the payee name is the particularly the Rainbow Papers payee, they have submitted the check, and the check is bounced due to inadequate funds in the account. And consequently, the respondent demand come legal notices under Section 138 has given, and it is a demand come legal notice, and the criminal complaint under Section 190 also under CPC, the 190 Section 1973 also read with whatever the sections are there, particularly NI Act 8081, 138, 141 and 142. Meanwhile, one Mr. Neeraj Paper Agency Limited, they filed the application. Actually, earlier, that is below 1 crore. And this case is not admitted in NCLT. But another person, Neeraj Paper Agency, the company owed more than 1 crore. Application section, he is also an operational creditor. NCLT by order dated, initiated CAR. So here, operational creditor 2, one is not filed, and the checks given by the promoter is bounced to that particular person. Another person, Neeraj Paper Agency, that debt is not paid by the company. On account of that one, then that they have filed, they have given a 8 notice, section 8 notice, and 9 also. They have filed the application, and the case is also admitted in the NCLT. So initiated CARP against the accused company, thus bringing moratorium into effect. So the Neeraj Paper Agency Limited, on account of that one only, the moratorium started. Then the directors, they are smart. They want to escape, and everybody is telling nobody should touch that company during CARP. Why? Because that is called calm period. That is called calm period. Once it is a calm period, nobody should touch that company, that too moratorium period. And everybody is talking that the IBC prevail over other acts like that. All these things are listened by the corporate debtor, and they have filed an application. The particularly the criminal case, imprisonment should not be done because the company is undergoing a corporate insolvency resolution process. In the light of which the applicant applied exemption from personal appearance under NI proceedings, which was rejected by Metropolitan Magistrate. No. Okay, IBC, I know it is a prevail over the other acts, but this is an exemption. They accept this one, the criminal proceedings that will continue as a status quo. The magistrate, Metropolitan Magistrate Court, they told rejected is NI proceedings. No. You have to undergo the particular imprisonment like that. The appellant then appealed to High Court, but meet with a similar fate. Then, based on the judgment given by the Metropolitan Magistrate, again the appellant is approached the High Court also. Hence, the appellant filed the present appeal. High Court also given the same verdict. Then the appellant filed with the Honorable Supreme Court of India. Sir, moratorium is going on, sir. The corporate debtor, I have given the check, but the criminal proceedings they want to initiate against the promoters who has given the check like that. Then the Honorable Supreme Court verified the total case. Analysis of the Supreme Court of India. Analysis of the Supreme Court of India in this case. The nature of proceedings under two statutes are different, that would not intercede with another. Different. Once the common, then IBC will provide. Once it is the different, there is no question of the problem. Under section 14 of Insolvency and Bankruptcy Code, the nature of proceedings that are kept in abeyance exclude the criminal proceedings. Whatever the proceedings are there, IBC will provide. And whatever the surface and other DRT cases, not attachment is not possible. Once the CARP is undergone, exclude criminal proceedings. Whatever the criminal proceedings against the company directors, that will continue. They have to undergo that particular, whatever the punishments are there. So here, section 14 of Insolvency and Bankruptcy Code, the nature of proceedings that are kept in abeyance exclude criminal proceedings. So that's why Honorable Supreme Court clearly and categorically given the verdict that two statutes are different and would not intercede. If at all intercede, then only IBC will provide. If at all the two are different, the different statutes, then there is no question of intercede. And section 14 also clearly states that nature of proceedings that are kept in abeyance, excluding criminal proceedings. That exemption is there. Under that exemption only, this the promoter has to undergo that particular criminal proceedings on account of a bouncing of check under section 138 to 142 of the NI Act 1881. The criminal proceedings under section 138 of NI Act arise due to default of financial debt. Once he defaulted the financial debt, which classifies as a penal and not recovered. Penalty 138 to 140, what they told? Penalize that particular person. It is not a recovery form. It is not use attach the property, sell the property like that. First, the wrongdoings are to be penalized suitably. Imprisonment. Second one is punishment, particularly the penalty also. Double the amount of the check also. It depends upon the verdict of the court. So here the criminal proceedings under section 138 of the NI Act arise due to default in financial debt, which classifies penal and not recovery. Penalty to be imposed. Penalize that a particular person, either imprisonment or the penalty, whatever it is. It is not recovery proceedings, as one may go under imprisonment or fine of both 138 of the NI Act. Clearly, categorically called clear the section. It is not a recovery form. That is a bouncing of check is not a recovery, this one. First, the check without adequate funds impose a penalty. Section 31 or section 38 to 41 of Insolvency and Bankruptcy Code, where the debt can be extinguished, would not ipso facto apply to the extinguishment of the criminal proceeding. Where the debt can be extinguished and would not ipso facto apply to the extinguishment of the criminal proceeding. So once the debt is paid, then this problem will not arise. Once it is not paid, then the penalty to be that to criminal, that to imprisonment. That is both are different acts. If both are similar, IBC will provide. Otherwise, as per NI Act, that imprisonment are to be punished by the magistrate court, metro magistrate court, that is to be continued. If the proceedings under section 138 of an already commenced, and if the company dissolved during the pendency of the proceedings, signatory or director would face a penal liability under the NI Act 1881. Even the company dissolved also already commenced. The proceedings of 138 already commenced, and if the company get dissolved during the pendency of the proceedings and would face penal liability, and even some other people, particularly those who are close, they dissolved the company. Still, if at all earlier during their tenure as a promoter or managing director, whatever the checks they have given, that checks are definitely, if adequate funds are not there, then the imprisonment or penalty will be there. Decision of the Supreme Court. where the proceedings under Section 138 of NI Act have already commenced. During the pendency, the company gets dissolved. Then the signature director cannot escape. In most of the cases, those who are giving the checks, that is a careful loss, particularly post-dated checks, If the checks are presented and not paid and a letter taken from the bank, that is suffice to file a criminal case against the drawer of the check. And the payee is always having a right to recover the amount from the drawer, and the court will also give penalty as well as imprisonment also. Cannot escape the penalty liability under Section 138 of the NI Act. As what is being dissolved is the company and not a personal liability of the excused under 141 of the NI Act. Cannot escape the penalty liability under Section 138 as what being dissolved is the company and not the personal liability of the excused covered under Section 141 of the NI Act. Thus, the proceedings under Section 138 in relation to signatory directive shall continue according with the law. The law is NI Act 1881, Section 138 to 140. That is separate. This is separate. Both are different acts. And if both are similar, IBC will prevail. Otherwise, IBC will not prevail. The imprisonment or penalty, whatever the Metro Magistrate Court given, that will continue. Even though during the particular this one, that is during the CIRP process, that moratorium is there, and please wait. Don't the imprisoned particular promoter or don't impose any penalty like that. That is not correct. That will continue. But here, the learning lesson. The learning lesson is whenever the debtors are there in the company, whenever the company is giving a credit to the debtors by taking the post-dated checks or the bill of exchange, all these things, that amount to be required, that is an asset. That asset is also eligible for appropriation of payments. That for a waterfall mechanism, that also not only the unpaid share capital of the shares, this also we have to require. This is also asset. Whenever the physical asset is there, we are selling and appropriate to the various stakeholders in the CIRP in the liquidation process. In the similar manner, whatever the data are there, what type of data, whether they have given the bill of exchange or not, whether they have given post-dated checks or not, if they have given the post-dated checks, the company, on behalf of the company, you are having the right to file a case to recover that amount, subject to COC approval, subject to adjudicating authority instructions also. Subject to COC approval, subject to the adjudicating authority instructions also. Because of that property, that asset is to be recovered. In case of liquidation, that amount to be recovered from the debtors and we have to pay. At the same time, whenever the company is given any post-dated checks and the creditors are, particularly the operational creditors or whoever is there, if they filed in the magistrate court or high court or district court, then if the court authorities are given the judgment for imprisonment or penalty. And how to we should not say that CARP is under process. Now it is the moratorium is there. You should not arrest like that. We should not tell, because two separate acts. The it is not similar, and here it is not recovery. NI Act is imposed the penalty. So this is one of the important judgment. The second judgment, the Honorable Supreme Court of India given. Any discussion on this point, sir? Any aspects? Sir, any discussion? Or shall I go for next, sir?
Yes, sir.
Okay, sir. Thank you, sir. Thank you. Now coming to the third case, the Honorable Supreme Court. M. Suresh Kumar Reddy versus Canara Bank and others. This is the third Supreme Court judgment, Honorable Supreme Court judgment. The first two cases are learning lessons are there, particularly the IRP or RP. In the first learning cases, whenever you are admitting the claims, you have to verify whether all claims are LIVA, live claims, or stale claims. Once it is stale, we have to reject the claim by mention the proper reason and brought to the notice of the Siva persons. You have to, why? Because once it is stale, that too various statutory acts. So that's why whenever admission is operational or financial creditor submitted the application, adjudicating authority verifies the genuineness and whether the claim mentioned is the live or stale. In the similar manner, whenever you are giving public announcement, you have to verify that one. That is a learning lesson. Simply, only it is not restricted to the adjudicating authority. It is applied for us also. As a IRP or RP, we have to verify the claims. Stale claims to be rejected. There is no validity. No court will accept. So, whatever the live claims are there, LIVA, live claims are there, we have to admit. So, verification of claims are very, very important. Even though while verifying the claims, if at all it is stale, then you ask any acknowledgement or continuation of a debt, any correspondence is there, you submit. Otherwise, this claim is not admissible. Like that, you have to reject. In the second case, the learning lesson is particularly this 138 to 142. This 138 to 142 is not only for directors. As an IRP or RP, all assets are to be verified. All assets are to be properly accounted for. And if it or you are leave it like that, the debtors amount mentioned in the balance sheet. What type of debtors? What is the age? Whenever the debtors loan is given by the company, what is the credit policy of the company? And whenever they are giving the goods on credit, that is called the debtors or bills receivables, whether they have given any bills receivables. If bills receivables are given, then subject to get the approval of the committee of creditors and brought to the notice of the adjudicating authority, you can file in the court to recover the amount. And most of the company, even banks today, whenever I am giving what type of loan is there, whether housing loan or car loan or personal loan or mortgage loan or term loan, we are giving post-dated checks. Post-dated checks. Once the installment is not paid, then we will take one letter. Once installment is not paid, bank can submit the post-dated checks in clearing. Once it is not paid, bank is having a right to take action against the drawer of the check, that is the borrower, under section 138 to 142. These are the two learning lessons. So whatever the data are there, whether the data, particularly the data, they have given the post-dated checks or not. Once post-dated checks are not, they are given, you present in clearing on behalf of the company, and once it is bounced, then you can take action subject to COC. Otherwise, that is also an asset. We should not leave that asset. Some of the people always, whatever the building, whatever the plant and machinery, whatever the person guarantor, all are there, correct. First, whatever the company assets are there, cash or the data or the bills receivable, or in the similar manner, whenever the post-dated checks issued by the company, and who is signed the authority, who has signed that particular check, whenever the signing of the check is there, the board resolution is there. That board resolution also, they will give it to the bankers for authorization of the issue by the check. So you can take from the bank also who is given the authorization. And if at all that checks are bounced, then you have to leave that particular corporate data whenever any magistrate court they have given any judgment for a criminal imprisonment or any case against him under section 138 to 1. That is the two learning lessons that are there in the first case and second case. Now coming to the third case, Messrs. Suresh Kumar Reddy versus Canara Bank and others. Third case of Honorable Supreme Court of India going to be discussed. Supreme Court said the decision in Vidarbha Industries is an exception, not a rule. In Vidarbha case, Honorable Supreme Court of India, they have given one verdict. Don't use that judgment to all the cases. That also they clearly mentioned exception. It is not applicable to all the cases. Case by case also, we should not apply the same rule to other cases. In this case, particularly Suresh Kumar Reddy and Canara Bank others, the Honorable Supreme Court of India, the particularly Vidarbha Industries, you have given the judgments are why not apply for this particularly in this case of Suresh Kumar Reddy versus Canara Bank. No, that is an exception. Based on the situation, based on the facts of the case, based on the people's particularly the operational creditor or financial creditor or the class of creditor or the whatever it is there, we have given the judgment. That is an exception. Don't apply that rule to other cases. What is that one? In May 2023, the division bench of the Supreme Court in Messrs. Suresh Kumar Reddy versus Canara Bank and others held that once NCLT is satisfied the default has occurred, there is hardly discretion left with it to refuse of the application, refuse admission of the application, under section 7 of the Insolvency and Bankruptcy. In May 2023, the division of a bench of a Supreme Court of India in Messrs. Suresh Kumar Reddy and Canara Bank and others held that once NCLT is satisfied that a default occurred, there is hardly any discretion left. No, they should not reject. Once a default is there, they have to admit. They should not they reject the application. Prima facie, the bank has given loan, document is there, account statement is there, bank is also given notices, borrower not responded, bank loan asset is also created, and all are gives the impression to the judiciary authority or adjudicating authority that the amount is not paid. He enjoyed that loan and defaulted. Once all are there, they are not having any discretion. The NCLT is not having any discretion with the refuser to refuse the admission of the application under section 7, that is financial creditor, that is a bank, in this case Canara Bank. What is that? Details we will go. Facts of the case. Syndicate Bank now merged with the Canara Bank. Once you might have experienced this one also. Most of the banks are merged. Andhra Bank merged with the Union Bank of India. And Allahabad the bank merged with particularly Indian Bank, like that. But whenever the adjudicating authority, they have filed, particularly Union Bank, any loan is defaulted, if they submitted Andhra Bank document, then the merger for the Government of India Parliament, they have taken the decision that government notification also to be enclosed with the admission application. Otherwise, they don't know about which bank was merged with bank, all these things, they may not aware of this. Syndicate Bank now merged. Even Syndicate Bank also, it is a Bangalore or Karnataka base. Syndicate Bank is also Manipal, and it is merged in Canara Bank, that is in Bangalore. Has sanctioned a secured overdraft facility to several bank guarantees to Kranti Edifice Private Limited Corporate. So, Syndicate Bank, they have given a overdraft facility and guarantee sums, that is called bank guarantees. Bank guarantees are called non-fund based business. Whenever the banks are giving up guarantees, they will take some the collateral security. Second one, cash margins. Suppose if at all you are asking for 100 crores guarantee, bank will take 24 crores cash, 75 crores the property worth. Then only they will issue the guarantee. Even though it is on paper, they don't violate the security. That's why they are secured creditors. Even bank guarantee is also fully secured. But in case the guarantee is bounced or devolved, then the total amount to be paid by the bank, they create the loan and they will first they will appropriate the first they will 100 if at all that guarantee taken in favor of the government, they will pay the amount. If the government told the contractor is not adhere the terms and condition, we are please pay the guarantee amount, means immediately for 100 crores we have to open the loan account. Whatever 25 crores cash margin is there, we will create to the 100 crores 75. Immediately we write a letter to the borrower, pay the 75. Otherwise, whatever the assets are given, that is mortgaged to that particular guarantee, we will sell it under surface 2002 and sell it in the market and appropriate the same. In this case, the syndicate bank sanctioned secured overdraft given, and as well as bank guarantees to Mrs. Kranti Edifice Private Limited, the corporate data. Some bank guarantees were in favor of state of Telangana. Bank guarantees, normally bank guarantees, government of India or infrastructure, whatever it is there, whenever they are constructing any barrage or river or any big projects, the government will ask the guarantees from the contractors. This also they have taken the guarantee, and some in favor of state of Telangana also. Subsequently, state issued a letter to syndicate bank to extend the bank guarantees. Actually, extension of a bank guarantees are to be done with the consent of the borrower. Particularly the guarantor, particularly the guarantees. If it is state government wants to devolve because of the contract is not adhered, then they will ask the bank to cancel the guarantee and pay the amount. But in this case, the state issued a letter to syndicate bank to extend the bank guarantee. Bank guarantee extension, they are asking. If at all they have given 6 months, they will ask another 6 months or 1 year, another 1 year, like that. The corporate data also wrote to syndicate bank. For extending bank guarantee, apprehend that the state might encash the bank guarantee since the contract with the state were due to pre-closure. No, don't extend the guarantee. Whatever the contract, we are pre-closure of the contractors, and the state might have encashed the bank guarantees since the contract with was state was a pre-closure, like that. They told like that. In this case, particularly first bank will listen the beneficiary of the guarantee, not the applicant. Applicant is the Mrs. Kranti, that is corporate data. Beneficiary is state of Telangana. We will always listen the beneficiary verdict on. Why? Because once we have not listened, nobody believe the bank guarantees. Nobody will recognize the bank guarantees, and it is a big problem to the trading community also. Beneficiary words only we will listen, not the applicant who is given the 25% cash margin or 100% cash margin or the security, etc. But this person told the corporate debtor also wrote a letter to syndicate bank for extending bank guarantee, apprehending that state might encash the bank guarantee since the contract with the state were due for pre-closure. Once the pre-closure is there, they will devolve the bank guarantee. In the meantime, they are asking X. Syndicate bank rejected the proposal of the corporate debtor. We don't listen. And asked to repay the entire outstanding. Okay. The beneficiary, the applicant told that the state is going to be encash the bank guarantee and don't renew, like that they told. Immediately bank rejected his proposal and asked them to pay the amount. Why? Because once the state government devolve and ask the amount, the bank is in a position to pay. So repay the entire outstanding. The Telangana High Court restrained the syndicate bank from taking coercive steps under letters of invocation of a bank guarantee. The state Telangana High Court restrained the syndicate bank from taking coercive steps under letters of invocation of don't take any the tough action against the borrower, etc., etc. High Court given. High Court given orders to the bank. The Telangana High Court restrained the syndicate that from taking coercive steps under letters of invocation of a bank guarantee. However, syndicate bank filed Section 7 of the petition against the corporator, which was admitted by the NCA. In the meantime, other way for the banks are there. If the borrower is defaulted, High Court what they told, don't take any coercive action against the corporator. Immediately bank under section. So I have given notice, he has not paid, default is there, so please admit. However, syndicate bank filed section 7 petition against the corporator, which was admitted by the MCLT. Aggrieved by the same. An appeal is filed by the NCLT by the Suresh Kumar Reddy, the appellant. A suspended director of the corporate data, and the same was dismissed. Once the NCLT admitted the case, the corporate data, that the promoter of the corporate data, he filed an application with the NCLT that NCLT appellant suspend as they agreed by the same. No, NCLT admitted the case, which is wrong. The High Court also told that don't take any coercive measures against the company. But NCLT also told, dismissed that application. The Suresh Kumar Reddy, who is the appellant of the particular promoter of the corporate data. The appellant then filed the present appeal before the Supreme Court. Again, Mr. Suresh Kumar Reddy approached the Honorable Supreme Court of India, stating that in Vidarbha Industry Power versus Axis Bank, it was held that NCLT has a discretion to reject or keep abeyance in a section 7 petition if there is a good result to do so. In the Vidarbha case, while admitting the case, the NCLT can take a view, and they kept abeyance also, and they are having a discretion to reject also. That is in the case of Vidarbha Industries Power Limited versus Axis Bank. Mr. Suresh Kumar Reddy told the same case similar to be applied in this case also. They approached the Supreme Court of India. So the appellant then filed the present appeal before the Supreme Court, stating that in Vidarbha Industries Power Limited versus Axis Bank Limited, it was held that the NCLT has a discretion to reject. But the Supreme Court told, no question of discretion. Once the default is there, that is confirmed, the proof all are there, and if the adjudicating authority believed that the default is there, there is no question of rejection except admission of the case. Has a discretion to reject or keep the abeyance in a section, is there a good reason to do so? That is different. Vidarbha case is entirely different. Here, what is the good reason? The amount is not paid. Default is confirmed. But High Court has given some, don't take coercive measures. What is the coercive measures banks are taking? Once the amount is not paid, then the bank will sell the property. It is not a coercive measure. It is a routine affair of the bank. Decision of the Supreme Court of India. The Supreme Court observed that decision of Vidarbha Industries Supra was given under very specific set of facts. Facts of the case is entirely different. and it cannot be read and understood in contradiction to the view taken by Innovative Industries Limited and ICICI Bank and another and ES Krishnamurthy and other versus Bharati High Tech Builders. Contradiction of the view taken. The same is not applied. Particularly, whatever the Vedarbha decision is there, it is not applied in Innovative Industries also. Innovative Industries Limited versus ICICI Bank, not same, they not implemented, not applied. And ES Krishnamurthy and others also. And another one is particularly and others, Bharati High Tech Private Limited, all these things, the same, that is a facts of the case is entirely different. In Innovative Industries Supra, the scope of section was explained and it was held that NCLT is satisfied there is a debt and the default, it is bound to admit. What is a debt? Document is there. What is a default? Once the bank is borrower is not paid, the bank will issue notice. Not one notice, a series of notice. And the loan is not one day, the loan taken, enhancement and documented, where document is available. So the debt is satisfied and the default is also satisfied. Once the default, once the borrower paid, show the particulars. Once he is unable to show the particulars, he is not paid the amount. Somebody, particularly operational creditor, file an application. Immediately, if the company has paid that amount, they have to inform to the adjudicating authority the IFSC number, the date of payment, the bank, and the acknowledgement, and whatever the payment made by them, whatever the receipt is there, all shown. Then the NCLT will not admit. So here, the debt and the default are to be satisfied. Once both are there, then the same was further reiterated in ES Krishnamurthy and others. Supreme Court concluded that instead there was no good reason for NCLT to exercise discretion under the rejection of a Section 77 petition. Today, if at all any application filed, some of the borrowers what it was, sir, we are with the bank, particularly we are doing the compromise or one-time settlement, or the company is in financial problem, or the company is in a COVID situation, it is not restored, or there is the market demand. All these things, if at all taken into consideration, no case will be admitted in the court. That is out of the purview of the court. Default, loan taken, default happened or not, that's nothing. Even today, some of the corporate debtor, through their legal advisors, they told now the corporate debtor is they approaching the banks, compromise, and the bank is also they released a one-time settlement. We are in the process, and please don't admit like that. No. Even adjudicating, because I am the eyewitness in number of cases, particularly in NCLT adjudicating authority, the room also, he clearly told, once compromise is there or one-time settlement is there by the corporate debtor, the financial creditor who submitted the application, he has to file the IA with us. Then only we will see. Otherwise, no question. Then they will ask the bank advocates also whether any OTS. No, sir, as on date, no OTS accepted. And OTS is a long-term process. And compromise also long-term process. So they have to pay some amount. And then only after total amount is paid, then only it is to be treated as a paid amount till such a time it is deemed to be treated that the loan is not paid and still it is in default condition only. So here, in this case also, particularly, the learning lessons. The learning lessons is whenever you are particularly filing an application in the NCLT, the corporate data, they will use so many strategies. No, sir, this problem is we are going to get 10 crores or 100 crores within a week. Don't admit we will pay. Some people, we are going to get tomorrow some amount. Once that is paid, we will liquidate. And the bank is also agreed, sir, for compromise. Bank is also agreed for one-time settlement. All these things are out of the purview of the court. Even adjudicating authority also clearly and categorically, they told once the financial creditor who submits the application, and whatever the voting rights are there, if voting rights are, then only they will stop. Otherwise, it will continue. Earlier, the same situation was happened in high court or district courts like that before implementation of the DRT. Because I presented number of cases. Particularly the promoters, they told, sir, some losses are there, sir. But this case, I am discussing with the branch manager. Branch manager is also soft corner. He is going to settle the case with lower amount, all these things. Court are not listening. They don't listen also. So this is also learning lesson. So these three cases, whatever the learning lessons are there, we have discussed it. And now we will break for tea. After 10 minutes, we will assemble. After that, two cases and some evolving of the IBC also, I will discuss in brief after discussion of the two Supreme Court of India judgment. Now, break for tea. 10 minutes, sir. Is it okay, sir?
Yes, sir.
Okay, sir. Shall I start now?
Yes, sir.
Okay, sir. Okay. So the fourth case I'm going to discuss, that is Messrs. Vistara, ITCL India and others versus Dinakar Venkata Subramanian and another. This is also the Honorable Supreme Court of India given the verdict. Whatever the judgment is there, we will analyze the judgment. Supreme Court clarified that secured creditors are entitled to retention of sale proceeds of shares pledged by the corporate debtor. So the secured creditor always is having a one facility or power. In case of a hypothecation subject to notice or it is not attachable. Suppose take for example stocks are not there. Banks has given a finance on the stocks, that is called hypothecation. And mortgage, banks are giving loans based on the land or building, that is called mortgage, creation of the transfer of property acts. Hypothecation, that is defined under Surface Act 2002. The pledge is whenever the banks are giving loans on shares, the shares, the pledge is there. Pledge means whenever the amount is not paid, they are having a right to appropriate the same. Even a gold loan, whenever as an individual, if at all I am taking any gold loan from the bank, the gold is to be given to the bank. So the property with the bank, and whenever the loan is not paid, the bank is having a right to sell and appropriate the same, then only they have to give whatever the surplus is there. That is the power of the pledge. Power of the pledge. So the Supreme Court clearly clarified that secured creditors are entitled to retention of the sale process of the shares of pledge by the corporate debtor. In this case also, the corporate debtor given pledge, particularly the shares of the group companies to the financial creditor for the loan given to the group, not to the corporate debtor. And later on, the corporate debtor undergone that particular CIRP. The resolution professional asked, why how they appropriate that pledged shares? No, you give it back and it is in the waterfall mechanism like that. Then the case is approached, particularly the parties approached the Supreme Court of India also in this regard. Pledge is having power when compared to hypothecation or mortgage. The position of the asset with the bank, the loan based on the position of asset, bank is giving loan. Once the loan is not paid, the bank is having a right to sell the possession goods, that is called pledge. That's why even if you verify that a particular the IBC code also, the pledge is somewhat different when compared to other creation of charges of the assets of the corporate debtor. What happened in this case, we will look into. In May 2023, the division of Supreme Court of India in Messrs. Vistara, ITCL India and others versus Mr. Dinakar Venkata Subramanian and another held that secured creditor would be entitled underlined to retain the sale proceeds. He need not give back to the IRP or RP during CIRP process. That is a shares pledged by Amtech Auto Limited corporate data under the Insolvency and Bankruptcy Code. No, you need not give the pledge, the sale process of the pledge. You can retain that one. The financial creditor is having a right to retain. Facts of the case. What are the facts of the case? The corporate debtor approached Messrs. Vistara ITCL India. The corporate debtor approached ITCL India and others, the appellants, to extend a short-term facility of 500 crores. The CD approached the financial creditor. The financial creditor is a Vistara ITCL and others to the extent of short-term loan facility of 500 crores to the corporate debtor, group companies, to the corporate debtor group companies. The loan is for not for corporate debtor group companies, including Brasco Engineers Limited, Brasco, and WLD Investment Private Limited, with the understanding that it would provide a first ranking exclusive security through pledge over its equity shares of the JMT Auto Limited. JMT Auto Limited. Now, several scrutiny security trust agreements were executed between the group of companies and the appellant also, particularly the financial creditor, the group of companies also. The several agreements are reached. Subsequently, application under Section 7 of IBC to initiate the proceedings of the corporate debtor. Accordingly, the resolution professional was appointed and the approval of the resolution plan. Accordingly, resolution professional appointed and the approval of the resolution plan was sought before the adjudicating authority. Adjudicating authority is acceptance is required. The appellant moved a claim of a corporate debtor secured creditor, which was rejected by the resolution professional. Particularly, the appellant means the financial creditor, a claim that the corporate debtor secured creditor claim as a secure corporate debtor's secured creditor was rejected by the resolution profession. Consequently, the appellant claimed right over the pledged shares. Actually, here, the corporate debtor's secured creditor is particularly the financial creditor, rejected by the resolution profession. Consequently, appellant claimed right over the pledged shares, because I am having the rights on that particular shares. Why? Because the shares are pledged to us. On the pledged shares only, we have given 500 crores to the group of companies, and the adjudicating authority dismissed the application of the appellants, particularly the financial creditor applications are dismissed by the NCLT, and they appealed before NCLAT. The financial creditor then appealed to the NCLAT, also dismissed on the finding that there is a claim as secured creditor has been rejected previously. NCLT rejected, resolution professional rejected, even though the shares of the group of companies are pledged to the shares of the corporate debtor pledged to the financial creditor for extending credit to the group of companies, not to the corporate debtor, not to the corporate debtor. It was added that appellants did not pay any financial debt to the corporate debtor. What is their argument? NCLT or the resolution profession or NCLAT means you have given a loan not to the corporate debtor, you have given a loan to the subsidiaries or group of companies of the corporate debtor. That's why the claim is rejected. Could not fall under the purview of the secured creditors. You are not secured creditors. What is the meaning of the secured creditor here? If the funds are given only to the corporate debtor by the financial creditor, then only it will be treated as secured creditor, or if the corporate debtor given a shares for the group of company, whether it is to be treated as a secured creditor or not, that is to be decided. But NCLT or NCLAT or the insolvency professional also, they rejected the claim. They rejected the claim of the financial creditor. Why? Because the financial creditor given a loan to the group of companies, not to the corporate debtor, not to the corporate debtor, but on account of that one, they rejected the claim. Being agreed with the decision of the NCLAT, the appellant moved to the Supreme Court. Particularly, the financial creditor has moved to the Supreme Court. Decision of the Supreme Court of India. What is the decision of the Supreme Court of India? The Supreme Court placed a trust on Anuj Jain Interim Resolution Profession for JP Infratech and Axis Bank and Phoenix ARC Limited in Kitul Bhai, Ramu Bhai Patel judgments, and concluded that the corporate debtor is not liable to repay the loans advanced, whereas separate agreements has already been executed by the lender with Brasso and Building. Here, the Supreme Court placed the trust on Anuj Jain Interim Resolution Professional for JP Infratech Limited versus Axis Bank Limited and Phoenix ARC Private Limited Ketul Bhai Ramu Bhai Patel judgments, and concluded that corporate debtor is not liable to repay the loans advanced where a separate agreement has already been executed by the lender with the brass and wheel. Correct. Now, the Supreme Court stated that appellant is a secured creditor was denied rights under 52 and 53 of the IB for the pledged shares. That is the point. That is the point. The Supreme Court of India stated that appellant, being a secured creditor, was denied the rights under section 52 and 53 of the IB Code for the pledged shares. The court considered the definition of security interest provided under section 3 subsection 31 of IBC Code along with the nature of a pledge agreement. It added that section 31 of IBC requires adjudicating authority to protect the interest of the creditors who are not in the committee of creditors. Even though the financial creditor is not provided a direct loan to the corporate debtor, but section 31 of I&B Code requires adjudicating authority to protect the interest of the creditors. He is also indirectly a creditor, not directly. Supreme Court held two solutions. What is the two solutions? To treat the secured creditor as a financial creditor of the corporate data to the extent of estimated value of the pledged shares on the date of commencement of CIR. To treat the secured creditor as a financial creditor of the corporate data to the extent of estimated value of the pledged security on the date of to that extent only the secured creditor is eligible to be treated as a secured creditor to the extent of estimated value of the pledged shares. To treat the appellant as a secured creditor in terms of section 52, treat as a section 53 of the Insolvency and Bankruptcy Code. Then the Supreme Court told the NCLT's order was modified partly by the Supreme Court, recognizing the rights and obligations of the appellants as a secured creditor under 52 and 53 of IBC Code. What is the 53 and 52 means? Once whether they are secured creditor or not to be defined up to the estimated value of the pledged shares on the date of commencement of CIRP, they are to be treated as a secured creditors to that extent. So that's why the Supreme Court of India, they instructed the NCLAT modify partly the recognizing the rights and obligation of the appellants as secured creditor under section 52, 53 of the IBC Code. Supreme Court, while proceeding to the second solution, made equitable interpretation of insolvency law and allowed application for liquidation proceedings during CIR. Whatever the leftover amount is there, the leftover amount is to be paid according to the waterfall mechanism of the liquidation process. So again, this case, once again, this is an interesting case, and we will go through once again. Supreme Court of India clarified the secured creditors are entitled to retention of the sale process of the pledge. Up to what level? Up to the value of the pledged shares by the corporate data. So are entitled secured creditor. Who is pledged this shares? Corporate data pledged such shares. In this case, what was happened? Corporate data not available. The shares belongs to the corporate data. The shares are given to the financial creditor, and the corporate data is pledged that shares to the financial creditor. But some agreement also reached with the group of companies by the financial creditor. Now the corporate data is under now the corporate data is under the CIRP. Whatever the CIRP is there, in the CIRP, the financial creditor also submitted some claim. What is that claim? Because the particular financial creditor is to be treated as a secured creditor. Whether he is a secured creditor or not to be determined under section 52 and 53 of IBC. What the secured creditor in this case means, up to the value of the particular pledged shares, the secured creditor, he is to be treated as a secured creditor, and accordingly that is to be factorized in the resolution plan. And whatever the pledged shares value beyond that amount, whatever the amount due, that is to be treated as an unsecured creditor, and as for waterfall mechanism, that is to be paid. But here the financial creditor contention is, once the shares are given, he is treated as that he is a secured creditor. Once a secured creditor means that is to be given in the resolution plan also, he has to be given priority. But the resolution plan, they have not given the priority. And thereby he approached the NCLT. NCLT also given the same the judgment. And the appellant, particularly the financial creditor, approached the Honorable Supreme Court of India. And the Supreme Court of India told, as per section 52 and 53 of IBC, the secured creditor means in this case, whatever the shares pledged by the corporate debtor to the financial creditor for the loans extended to the group of companies up to the security value, he is to be treated as a security creditor. Whatever the beyond that amount is there, that is called unsecured creditor. Accordingly, this is also to be included in the resolution plan. Because the adjudicating authority is to safeguard the security interest of all the secured creditors or creditors. So in this case, up to the value of the pledged security, secured creditor, beyond that, whatever the amount is there, that is called unsecured creditor. In this case, 500 crores are loan taken and shares are pledged. If shares are 300 crores value, 300 is secured, remaining 200 is unsecured. This 300, because sale process is having a right to appropriate in the loan account, and remaining 200, he is not a secured creditor, he is an unsecured creditor, because the security is available to the financial creditor is up to the extent of estimated value of the shares pledged by the corporate debtor to the financial creditor. So here the case is clear, and but the context of the financial creditor is even not only this one. Today, whatever the banks are giving loan, this is a learning point is there. Here, the beautiful learning point is there. What is that learning point? All corporate loans, whatever the corporate loans are there, all corporate loans are not fully secured. It is partially secured. Suppose one X company is there. They are going to avail some loan, 100 crores. Banks are not getting 100% the collateral security from them. So some portion is security is there, remaining is unsecured is there. Even while the loan is defaulted, the loan is split into two categories. One is a secured portion, second one is an unsecured portion. That is also we can take into account. That also we will take into account. Bank's classification is correct. Once the loan is given, once the loan is turned into bad, the total outstandings a bank will split into two categories. What is a secured, what is a unsecured? And the unsecured bank will provide 100% provision. Secured portion, they don't provide provision. But once the secured portion, once the loan turn into doubtful, even a secured portion also they will provide the provision. But in this case, what was happened is the financial creditor who provide the loan to the provide loan to the group of companies of the corporate debtor, but always the financial creditor told, I'm the secured creditor. Why? Because shares are pledged by the corporate debtor for the loans availed by the group of companies. That is not correct. Why it is not correct means, whatever the estimated value of the pledged shares are there, out of the 500, if the pledged shares value is 300 crores, to that extent only he is a secured creditor. Remaining is to be treated as an unsecured creditor. So accordingly, while finalizing the resolution plan, the unsecured portion is to be take and the remaining 200 crores should not be taken as a secured creditor. It should be taken as an unsecured, and accordingly the resolution plans are to be accepted by the particular COC in the process. So this is one beautiful case, particularly when the company is in once the financial creditor is submitted his claim, we have to verify thoroughly whether it is comes under secured or unsecured. And in this situation, the secured, unsecured, both are there. The secured portion is up to value of the shares. Unsecured is the beyond the value of the shares. Suppose in this example, 500 crores are there. The value of the shares are 300, remaining 200 to be treated as unsecured. And accordingly, that is the whatever the liquidation value, how much he is going to get, all these things are to be taken into consideration while arriving the particular. Hello, sir. I will appearing for IP exam. Which case law book to refer for preparation? Sir, here, if at all you are going to appear for LIE examination, that is a limited insolvency. Sir, only for others, I'm taking only 5 minutes to one clarification asked by the participant. LIE exam, preparatory exam, they are going to conduct this one. For the case law, sir, case laws books are not required for IP exam. Most of the people, that is a myth. And they are reading the High Court, Supreme Court, NCLT, NCLT like that. 70 marks case studies are there. One is on CIRP, second one is on liquidation, third one is on PPIRP, fourth one is on individual insolvency, fifth one is code of conduct of IP, last one is on partnership or business loss, one case study. Only 5 marks are there for deciding cases. Only 5 marks. For 5 marks, nearly 60 case studies are there. Some case studies on Supreme Court, some case studies on High Court, NCLT, NCLAT, like that. 60 are there. For that 60, only if you go through that one, then you will get 5 marks. That 5 marks are also very easy to get it. 100% you will get it. But this is relates to the the one example I am quoting here. Only one example. Then I will go through the next Supreme Court judgment. They will ask in Innoventive Industries versus the privately the Inventive Industries Limited versus ICICI Bank. What is the subject matter? Particularly on which subject the case was given judgment. The case is once adjudicating authority must be satisfied with the existence of debt, then he has to admit. That's all. They will give in Innoventive Industries versus ICICI Bank. What is the subject matter? Adjudicating authority must be satisfied with the existence of a default before admitting the case. Before admitting the case, the adjudicating authority must satisfy the existence of default in which case? Innoventive Industries Limited versus ICICI Bank, like that. So, like this, that is very easy. But we have to they prepare in a structured manner. The books and other things for preparation of examination is not required. For practice, it is very much required. For practice, it is very much required. That's why at the time of starting the course, the class I told about the learning curves. The learning curves of ICSI IPA, they are they only one page, daily 2 or 3 or weekly 3 or 4 they are uploading. Go through that. For LIE examination, I'm taking, if at all you are going to appear for the the IP exam, that is LIE exam, and please the that is on which date I don't know, but first day I'm taking the class.
Sir, it is on 28th to 30th August.
Yes, on that day I will give a beautiful presentation how to complete the examination within a short span of time. Yes. Okay, that is a leave it off. That is regarding to LIE examination. The last case, Tuttampudi Salalith versus State Bank of India. This is also very interesting case. This is also very interesting case. What is that one? Supreme Court clarified limitation period for initiating CIRP and the lodging of claims during CIRP based on debt recovery certificate of the financial crisis. Sir, here what has happened is, first banks earlier, they preferred to file an application under the in DRT, Debt Recovery Tribunal. Some banks, instead of filing the application in Debt Recovery Tribunal, they are using SurfaceY Act 2002. Before SurfaceY 2002 and the Debt Recovery Tribunal, banks are used to file the applications for recovery in magistrate court, district court, high court, Supreme Court, like that. But in 2016 is it is a great help to the bankers. It is a great help to the bankers. Now all banks, they are happy with the IBC. Today, the corporate debtors, once the loan is defaulted, they know the total picture, what is going to be happened to the company, what is their positions. They are no more managing director. They are no more the director. They have to sit on the backside of the committee of creditors without voting rights. But here, what has happened is some of the cases of the banks, Debt Recovery Tribunal, they have given the judgment and they have given the recovery certificate also. And banks, they are not executing the recovery certificates and immediately they are filing with insolvency and bankruptcy, IBC. So, in that particular scenario, the Debt Recovery Tribunal, 5 years, the case was run, they continued for 5 years. After 5 years, a recovery certificate. After recovery certificate, again, the banks are approaching NCLT. Whether documents are hold good or time barred, that is a question mark. That is a question mark. So here also, based on this only, the particularly some of the appellants, they approached the Supreme Court of India also. Supreme Court clarified limitation period for initiating CIRP and lodging claims during CIRP based on a debt recovery certificate as a financial debt. Based on this only, the Supreme Court has given some judgment. I will brief about this thing. In October 2023, the Supreme Court of India in Tottampudi Salit versus State Bank of India and others has affirmed its previous judgments that a debt recovery certificate holder shall have from the date of recovery certificate 3 years to initiate. Today, DRT given final judgment. Once they have given the judgment, they give the debt recovery certificate also. And they appoint one recovery officer of DRT also. He will support it to the bankers. If the banks are willing to file the same case under IBC also, within 3 years they have to file. Otherwise, the documents are getting time bound. The documents are getting time bound. So here, once a DRT given judgment, the judgment will be based on the recovery certificate. They will give the judgment recovery certificate also. Recovery certificate means the banker is having a right to recover the loan from the corporate debtor. From that date to 3 years, if the banks are wants to file the same case in NCLT, they can file. After 3 years, if the banks are filed the case in NCLT, NCLT don't admit the case. So here, in October 2023, the Supreme Court in Tottampudi Salit versus State Bank of India and others has affirmed its previous judgments that held a debt recovery certificate holder shall have from the date of recovery certificate 3 years to initiate CARP proceedings and 12 years to lodge claim in CARP if it is pursued deemed decree. What is the case? What is the case? Facts of the case. Mr. Tottampudi Salit, the appellant, was the managing director of corporate data. And his respondent to is Tottam Infrastructure Limited company. He is a managing director. He is the appellant also. Very good. The corporate data defaulted on loans. Okay. And facilities extended by several banks. Okay. Lot of people consortium. Once the number of banks are given to one borrower, then it is called a consortium or the multiple banking also. The exposed lenders issued notice. First, normally banks will start recovery with the surfacing. Why banks are started with the surfacing? Why? Because here the cost of legal proceedings are very less. Bank will not incur any law. Too much legal expenditure will not incur. IBC is a costly. Why? Because I have to pay to the insolvency professional. Monthly 2 lakhs or 3 lakhs, whatever it is there. Next, second one is COC meetings. Third one is the valuation of all the property from the two valuers, plant and machinery, land and buildings, and business valuation. And PUF transaction, preferential, undervalue, extortionate, and fraudulent transaction, that transactional audit to be completed. And the expression of interest, I have to give the advertisement. Before starting, I have to give the public announcement. All these things a costly one. Today, the banks are also thinking about whether to file or not to file the case in NCL. Once the case is filed, time, money, first initially to be borne by the bank only. Anyhow, the loan is defaulted. Along with the loan, I have to incur the amount means then it is a bank problem is there. In this case also, the managing director of the corporate data respond infrastructure. The corporate data defaulted loans and facility extended by several banks. Okay. The exposed lenders are issued notices under section 13, subsection 2 of the SURFACE. Normally, 13.2 or 13.4 notices banks are issuing. Once the loan is defaulted, we will issue 32. That is called SURFACE. Under SURFACE section 13, subsection 2, 34 sale notice. These two are common. Once these are not gives a result, some banks they will prefer a debt recovery tribunal within their reach. Some banks they will prefer to file in NCL. Third stage only. First stage SURFACE, second stage debt recovery tribunal, third stage NCLT. Before SURFACE also, bank will issue legal notice, normal notice. Bank will physically meet the borrowers. All these things are there. All these things are there. And whichever is the cost effective, the banks will try. And the SURFACE and later initiated. So they exhausted the efforts of the SURFACE. And later initiated recovery proceedings against corporate debtor before debt recovery tribunal. The 3 recovery certificates issued by the debt recovery DRT, 8th September 2015, 1 recovery certificate, 17 and 17 respectively. They have given recovery. Because on account of various loans, each and every loan, they listen and whatever the arguments, counter arguments and all these things listen. Finally, they have given 3 notices for 3 loans and they take the portion of the asset and sell it in the market. Like that, the DRT has given. Okay. Based on the certificate, that is a debt recovery certificate, SBI applied section 7 of the IBC code to initiate CIRP against the corporate debtor. But here, whenever the State Bank of India is going to file a application in NCLT, based on the debt recovery certificate given by the DRT, in how many years? Within 3 years. From the date of recovery certificate. If at all they have filed after 3 years, then the NCLT should not admit, because that is to be treated as time barred debt. While adjudicating authority, the NCLT considered the letters. Adjudicating consider the letter dated 29/1/2020 sent by the corporate debtor to the Union Bank and SBI acknowledgement update. Subsequently passed the order dated 12/1/2021 admitting SBI's CIRP application. Here the mistake lies. Actually, while admitting the case, the adjudicating authority has to verify whether the recovery certificate given by the DRT is within the time 3 years or not. That is to be verified. But 3 years across. at the time of filing the application. At the time of filing the application by the State Bank of India and the Union Bank of India in the NCLT, by the time the recovery certificates given by the DRT is more than 3 years, then this case should not be admitted. But here, the corporate debtor was sent some information to the banks. I borrowed this much amount. I promised to pay this amount at the earliest or within 2 months, like that. One intimation sent by the borrower. That is when it was happened. That is acknowledge while adjudicating that NCLT concern letter 29/1/2020 they have sent. Who? The corporate debtor sent one letter. This letter is after filing the application, not before the filing the application. This is to be accepted or rejected. This the application has to be accepted or rejected under section 7 of the IBC. This is to be rejected. Why? Because at the time of filing the application, the debt recovery certificate given by the DRT is more than 3 years. That's why that application is to be rejected. Right? During the process, after filing the application, in the meantime, the corporate debtor given one letter. Sir, I promise you to pay amount and within 2 months or like. Then NCLT consider this 2020 letter as an acknowledgement of debt. Then Supreme Court told, no, that is not correct. Whatever the acknowledgement of debt is there on the particular debt, that is prior to the filing of application, not after the filing of the application. While adjudicating authority, the NCLT considered the letter dated 29/1/2020 sent by the corporate debtor to the Union Bank and State Bank of India as an acknowledgement of debt, and subsequently passed the order, the appellant NCLT's admission order in NCLAT. Then that appellant is submitted. No, sir. That is already time barred. The time barred debt is admitted by the NCLT, which is wrong. Don't be treated that this one as a live debt like that. But NCLAT also broadly agreed the reason of the NCLT and sustained the judgment, hence the present appeal. They also, no. Subsequently, they have given that is to be treated as a NCLT, and that is to be treated as a acknowledgement of debt. Then, appellant contention. Appellant, what is contention? Pursuant to section 18 of Limitation Act, sir, in courts, particularly courts, they are thorough with the Limitation Act. In the Limitation Act, last schedule of various agreements and the particular particularly the limitation period also they will mention 3 years or 10 years. Take for example, mortgage property is there. Mortgage property. One example I am quoting here. I have taken 100 crores from the bank. And I have given a building and a land 60 crores. building and land 60 crores. This 100 crores I have taken for acquiring plant and machinery. The company is in loss. I have defaulted. But what the bank will do, the bank will file an application in DRT or surface, whatever the legal measures are that they will do. First, they will sell the property. How much they property the mortgage given 60 crores. They sold in the market, they got 70 crores. Out of 100, example only, out of 100, 70 crores appropriated, remaining debt how much? 30. That 30, particularly the plant and machinery document is that is called articles of agreement. On the articles of agreement, whatever the shortfall amount is there beyond the collateral security, that is to be paid by the company. Then I will use the document and I will approach the court and I will try to recover that amount also. Now coming to second scenario. Mortgage document, 12 years. The mortgage is 60 crores. That the 100 crores loan. And particularly plant and machinery document also taken. But mortgage document revival letter not taken after 3 years. Revival letter for mortgage documents and particularly the plant and machinery documents are not taken any revival letter. Then whatever the collateral security is there, the bank is having a right to sell the property. And the remaining balance, whatever earlier situation 30 crores, they are unable to proceed against the plant and machinery document. Why? Because the documents are 3 years completed. Once within 3 years or after 3 years also, if they taken the acknowledgement of debt, the remaining 30 crores they can recover. Third scenario is I have taken 100 crores. I have given document for plant and machinery and collateral security 70 crores. That is a mortgage to the bank. This was not paid by the time bank not initiated court. 12 years completed that mortgage, and 3 years after 3 years no acknowledgement of debt for the document and no acknowledgement of debt for mortgage also they have not taken. Then borrower is not to be paid. The borrower, the court will give the judgment. Bank is not having any right to recover single rupee from the borrower. Because of that mortgage of a building, whatever it is there, that period of limitation is 12 years. After 12 years, the bank is not having any right to sell the property. Why? Because mortgage title, it's a period of limitation is 12 years. After 12, before 12 years, the bank has to take acknowledgement. If not taken, that asset is also invalid. This is also 3 years not taken, both are invalid. So that's why period of limitation is very, very important. Pursuant to Section 18 of the Limitation Act, 1963, any acknowledgement beyond the period of limitation would not revive the right to sue. So that's why whenever the banks are filing the applications, as an IRP or RP, we have to verify whether the documents are in force. In force means within the period of limitation is there or not. Section 238A of Insolvency and Bankruptcy Code, it stipulates the application of the statute limitation of IBC code also, INP. Earlier, some of the people for IBC, limitation period is not applicable. After that, Section 238A stipulates the application statute of Limitation Act is also applicable for IBC. There is no exemption at all. The date of default should go back to the date of the loan account of the corporate as a declared non-performing. What is the date of default? From the date of default only, the limitation period will start. Date of default only. Suppose I take for example, you are taken a housing loan, 15 years. Housing loan for 15 years. As long as you are paying the monthly installments, that is equated monthly installments, banks are not taking any revival letter. Once it is stopped, not paid, from that date, within 3 years, you have to take the acknowledgement of debt or file the case in court. Why if at all you are continuously paying the amount, bank is not obtaining revival letter means, in Limitation Act, two are there. One is acknowledgement of debt, second one is the part payment of debt. If you paid the amount, some amount in the loan also, your document will revive. If at all you are given letter also, your document will revive. That's why section 18 and 19 clearly states the part payment of debt and acknowledgement of debt. The default should go back to the date on which loan account of the corporate debtor is default. Banks have approached debt recovery, were barred under the doctrine of election from approaching the NCLT for recovery of the same set of debts. Once the recovery certificate given by the DRT, that is as good as a judgment. Within 3 years, you have to, if you wish to file a case, the same case in NCLT, you can file, but within 3 years, not after 3 years. Decision of the Supreme Court of India. The Supreme Court addressing the contention. First and second of the applicant referred the Kotak Mahindra Bank Limited, Balakrishna and others, where the financial creditor will be entitled to initiate a CIRP within 3 years from the issuance of the recovery certificate of the DRT. So, whenever, today what is happening means, when compared to DRT, IBC is more comfortable to bank. DRT, some inadequate staff is there. DRT, they are taking 3 to 4 years or 5 years like that. And the surfacing, once the banks are initiated surfacing, counter attachment, they are approaching a high court, they are telling so many things are there. That's why banks are preferring NCLT. Okay. For DRT existing cases also, if the banks are willing to file in NCLT, they can file, no problem. But if at all case is under hearing, the bank can approach NCLT. In that case, limitation period will not arise because the court judgment is not given and the recovery certificate is also not given, no problem. Once judgment is given, recovery certificate is given, within 3 years, you have to approach the NCLT. So the NCLT reasoning that the procedural wrong corporate data letter dated 29/1/20 issued post filing of Section 7 petition of the INB code. Here, the NCLT, NCLAT, they have not identified this important area. What is that important area? At the time of filing the case, whether 3 years are completed from the date of recovery certificate given by the DRT or not, that is to be ensured by the NCLT. Normally today, within 14 days, they have to admit the case. That is not happening. Some cases 6 months, some cases 1 year also they have not admitted. Particularly in my case, the personal guarantor to corporate debtor, till date it was not admitted. Even after 2 years also. Postpone, postpone, postpone. So in this process, if the banks are received any letter from the financial, if the particular banks are received any acknowledgement of debt from the corporate debtor, stating that I'm going to pay the amount, that is not to be treated as acknowledgement of debt. Why? Because it is a post filing of the application, not pre-filing of the application. So in this case, that NCLT reasoning was procedurally wrong. NCLAT's reasoning was procedurally wrong. As a corporate debtor dated 29/1/2020 was issued post filing of section 7 of the petition of IBC code. Therefore, in the absence of amendment pleadings, the NCLAT could not take an purported acknowledgement of debt to extend the limitation. That's why that is the acknowledgement of debt. This is before filing the application. If it is given, then it is a fine for it is to be treated as a acknowledgement. Post filing, not to be treated as a acknowledgement of it. The court also clarified, as per BK Educational Services Private Limited versus Parag Gupta and Associate and Babulal Varadaraj Gurjar versus Veer Gurjar Aluminium Industries Private Limited and another decision. The date of default shall be the date of which limitation periods start kicking. So here, the limitation period will start from the date of default. That's why even a DRT recovery certificate also, the recovery certificate taken from the DRT, that is also adjudicating authority, and I approached the borrower, not paid. Immediately, I am eligible to file the case, same case in NCLT also. That too before 3 years. If 3 years completed, after that I filed the application, the NCLT, they have to reject my application. But in this case, what was happening means, so the case filed, after that, whatever the corporate data are given some acknowledgement, that acknowledgement also filed by the financial creditor in the court. That is a post filing of the case, and NCLT, NCLAT, they have taken the post filing of the application. Supreme Court told that this is not correct. On the appellant third contention, Supreme Court referred in the Oshudi or Bojwani Abhyudaya Cooperative Bank Limited and another. The date of recovery certificate was treated to be the date on which the time limitation began kick. Or Bojwani and Abhyudaya Cooperative Limited, where the date of recovery certificate was treated as to be treated on which the time of limitation began to kick. In both cases also, the period of limitation will start from the date of recovery certificate issued by the DRTs. When discussing the fourth context of the appellant, the Supreme Court stated that a doctrine of election bar prosecution some right to two different fora based on the same cause of action. However, in the instant appeal, recovery proceeding DRT commenced in 2014. IB cause was not existence at that time. Moreover, in Kotak 1 was held that the recovery certificate would give rise to fresh cause of action to the financial creditor. The doctrine of election cannot be applied to prevent the financial creditor from approaching NCLT for initiation of CARP process. SC concluded, which has been filed before the authority as a composite application based on the recovery certificate of 2 were passed in 2017 within 3 years of postulated Article 137 of limitation. Therefore, section petition relating to this maintainable. Regarding third recovery certificate, 2015, SC observed that the recovery dues that also cloth or character of the decree as for the so-and-so article, 12 years for enforcement. Here, finally, the Supreme Court of India told to submit the application in NCLT from the DRT recovery certificate to 3 years. For submission of claims in CARP, 12 years they have given. 12 years, that limitation also given. So, therefore, as per the decision, Kotak Mahindra SC opined that pursue that recovery certificate deemed to be decree, he will get 12 years to lodge the claim in IB court proceeding to. If the financial creditor wants to pursue the recovery certificate deemed, he will get 12 years to learn. Here, even though your application is rejected on account of the time barred recovery certificate, still you are eligible to file the claim. To file the claim from the date of default to 12 years in CARP proceedings and to submit your application in NCLT 3 years from the recovery certificate. Finally, Supreme Court, what they told is two. One is, if the banks are interested to file their application for CARP after completion of DRT proceedings, the DRT certificate date 3 years from the date of DRT certificate. That is one. If 3 years are completed, if the banks are filed, the NCLT will reject. The other alternative to the banks are available. What is the other alternative is, if at all anybody is filed against that corporate data, the claim can be filed by the financial creditor within 12 years. Within 12 years from the date of default of the loan. From the date of default of the loan. These 2 points are to be remembered in this case. Therefore, finally, as per a decision in the Kotak 1 and Kotak Mahindra Bank new precisions parts, Supreme Court will find that if the financial creditor want to pursue the recovery certificate as a deemed recovery, he will get 12 years to lodge the claim in insolvency and bankruptcy code proceedings. And Kotak Mahindra Bank versus New Person Limited, the Supreme Court opined if the financial creditor wants to pursue a recovery certificate deemed decree, he will get 12 years to lodge the claim in IB proceedings. Here, the 2 points are to be finalized. One is 3 years, second one is 12 years. The 3 years is if the bank is wish to file application 3 years from the date of a recovery certificate issued by the DRT, or if 3 years completed, then 12 year, particularly the 12 years are available for the bank to lodge a claim. If anybody submit an application to recover their dues, they are eligible to submit that claim. So these are the important. That's why I discussed about these 5 cases. And some of the participants, they told about IP examination. IP examination is very easy, not a difficult one. But strategic thinking is required, and a syllabus-oriented preparation is always required. Once the syllabus-oriented preparation is there, definitely it is very easy to complete the examination. Anyhow, ICSI, IPA, they are going to conduct the LIE exam also. And whatever the strategies are there during that time, I will describe that one. So in this, again, 5 cases, a synopsis, particularly in the next education, here, with regard to at least 3 preceding date of filing, several invoices are filed. In the several invoice, some of the invoices are stale, some of the invoices are not stale. When the NCLT is going to admit the case, they have to take only the live invoice, not reject the application based on the oldest invoice. That is the first case. Second one is 138, particularly bouncing of check. Some of the directors, they are giving the checks without any balances, even post-dated also. And after CIRP moratorium is there, it doesn't mean they should not take any action. The metro magistrate should not take any action on the directors. That is wrong. Always people are believing that IBC will prevail over any other act, but some exceptions are there. That is a second case. Third case is that particularly Vidarbha Industries, the default is once the default loan taken and the default happened, then the NCLT should not reject the application. But in Vidarbha Industries, it is an exceptional cases. Case by case, we have to analyze and we have to extrapolate that other cases with these cases, because the entire difference is there. Next one is the Vistara, particularly pledge. Here, secured or not secured. The financial creditor requesting the RP or NCLT, please treated me as a secured creditor. Why secured creditor? Because he has given a loan to the group of companies of the parent company by taking the shares of the parent company, and on that basis, his contention is that he is a secured creditor. But Honorable Supreme Court told, okay, up to the value of the particular shares, you are secured. Beyond that, you are to be treated as a unsecured. And accordingly, is a role, particularly is a place to be identified in the resolution plan or in case of liquidation waterfall mechanism. Next one is that is this Satya limitation period, debt recovery certificate, particularly debt recovery certificate. Once a DRT given within 3 years, if the bank is wishes to file in NCLT within 3 years, and after 3 years, it is not admissible, it is not valid to file an application under section 7 of the IBC. And if at all, it is documents are particularly recovery certificate is invalid on account of completion of 3 years. Another option is there to the particular financial creditor. He can submit his claim to the other persons who submitted the application, and that is within 12 years from the date of default to 12 years. So these are the cases. Anyhow, thank you very much for giving me the opportunity by the ICSI IPA, and those who are interested, they can take the LIA examination. We will give the whatever the strategies are there to complete the examination. Thank you very much, and a good night to all.
Thank you very much, sir, for taking out time and addressing such a nice session on the IBC case laws. And sir, please share the PPT so that we can share with the participants.
Thank you, sir. Thank you very much.
Thank you.